the first to know Nsem-Pii TV.
The national chairman of the National Democratic Congress, Chairman Edudzi Admits, and Nsem-Pii, the famous quote, "Any fool can go to court." Na ene nsema akoso hono na ebro adwene na ntiase so. After the full ruling of Justice forcing a Japan on the Mandamus application, you hear various reactions by various stakeholders from interested parties such as the National Democratic Congress Legal Council and the New Patriotic Party, as well as the Electoral Commission on the legal team. But one particular reaction, and I draw your attention. Yeah, there's a reaction, no. You become wasem kakra and sana yako various rulings by for the Ablekuma North constituency, the entire Mandamus application, judge and grantee. That is the reaction by lawyer Edudzi Admits. Ye story we now see audio na so na obenya evidence based on the air canon. Lawyer Edudzi Admits say enanopa oba on any team no omnim say case ombelusu because nkofo bebre court o ma dwene ne say me masema make no menim say e asempa me wonyina so a me de kasa asem we intikia ne kemedi nkunim. This is the another repeated orchestration by the National Democratic Congress. Monim say munni case na so na mo kwa akopre wo court. Same thing happened in the year 2020. Now the chairman of the National Democratic Congress in him said munni case fighting against the election petition. Now so no more court. This time no lawyer Edudzi Admits no abonenu mutu say omo ba no pa no munnim so be lose case based on preliminary objection ye overruling ya on this Mandamus application. No one no say obelusu na so no more back court omo prepare omo document omo the person call the Court of Appeal. It's a lawyer Edudzi Admits onim say only case in this Mandamus application. Now so na or share grassroots for no kutupa so omo case in this Mandamus application na odi omuti akoshiji yenko justice force in Japan ruling on the buy on the Ablekuma North constituencies. The differences are already no ye the Tema Central or Kaikoi Central the enswaba ye wi ani ekotie audio a chere statement lawyer Edudzi Admits kan after this court ruling based on the fact that no minimum say ombelusu sa Mandamus application to the New Patriotic Party. Now, the High Court General Jurisdiction Division 2, presided over by the learned the same judge, Justice for Japan, has granted the Mandamus application brought by Nana Ekuya Efri, a parliamentary candidate for the New Patriotic Party for Ablekuma North against the Electoral Commission for the coalition and declaration of the election results. Same pattern, election results, omunwie e wa Ablekuma North. Nana Ekuya Efri, parliamentary candidate, ebesre court and say on granting the Mandamus application for the public officials of the Electoral Commission, so all will be performing on duty. The Honorable Court heard arguments for and against the applications by the learned Gary Nimakumafo for the applications Godwin Tamakro Esquire for the interested parties, which are the National Democratic Congress parliamentary candidate and the party itself, and the learned respected Justice Amenuvo for the respondent of the Electoral Commission of Ghana. Same court, same legal counsel for the various parties. High Court judge, after spelling out as regard Mandamus and with a well-laid outline of the applicable laws on supervisory powers of the court, Justice Forsen moved on to apply the evidence in the Mandamus to the conditions of the Mandamus. Particularly for Ablekuma North constituencies, weigh any the facts of the matter. Vote of 62 polling stations was not collated. Tema Central by say 2. Okaikwe Central by say around 31. Ena Ablekuma North a whopping 62 polling stations not collated. Justice Forsen held that the inability of the Electoral Commission to collate these polling stations remains outstanding, and therefore there still remains a duty to be done by the Electoral Commission. Justice Forson went on to hold that there was a demand on the EC, which demand has been refused, as coalition, including the outstanding two, is yet to be done. Justice Forson held that all other conditions were met for the grant of the mandamus for coalition and declaration of Ablekuma North constituency. Consequently, Justice Forson ordered the EC to collate the 62 outstanding police stations and declare Ablekuma North parliamentary elections. The High Court Justice also consequently ordered the police to provide armed security for the coalition exercise. Consequently, all 62 polling station results shall be added to the already 219 polling station results. Into 219 and a normal kind were Ablekuma North, pending 62. And the 2 mandamus applications has been granted, one to the Electoral Commission officials, so Omunwie 62 polling stations, the other to the IGP of Ghana Police, so on provided the necessary security na election officials omuntiminye say jumare and performing the needed declaration. What is instrumental and then they say na Edudzi Tamaklo, lawyer of the National Democratic Congress, Oba Court no Nsem-Pii say omobelu case and say no one prepare the appeal document. That you could see some of the reactions after the ruling of the Ablekuma North constituency.
And of course, security is tight. Security is tight. I can see former Attorney General Mariata Bruapiaopong walking out. Just right behind her, I see Dominic Ayene, former Deputy Attorney. I see Joyce Bauer, who spoke for then candidate Mahama. A host of other lawyers who are coming out of the courtroom now. We are still waiting to see the candidate, the parties themselves, the people who brought these applications to court. And also, you can hear singing has erupted. We can now confirm authoritatively that the High Court has ordered that all coalition in all 4 constituencies be done for the constituencies. We will try to speak to some of the people who came in this matter. Let me just try to speak with Ebi Bright and some of the lawyer Dafiemapo is speaking.
The evidence before the court in respect of Tema Central, uncontroverted, was that it was not the case that, as alleged by the applicant, that there was no collation. Indeed, there was a collation and a declaration, but that out of 148 pink sheets, 146 were collated, save 2 that the NDC opposed. Now, we opposed those 2 pink sheets on grounds that they were fabricated after the close of polls on December 7th at 5 p.m. Now, we invited the presiding officers in respect of those 2 polling stations. They came to admit that when the polls closed, they were tired, they were exhausted. So they brought the pink sheets to the office of the EC, and they were instructed by their EC Metro Director to complete them. How do you complete a pink sheet in the office of the EC after polls have closed?
Were you giving copies of these?
They gave us a duplicate. The duplicates, therefore, the duplicates that we had, the pink sheets in dispute. I want everybody to appreciate this matter today. The 2 pink sheets in dispute in Tema Central, the duplicates that we have, that was how I was able to detect it. The duplicate did not contain the information contained on the original that the EC was urging upon us to approve. Why? The duplicates that we have did not have the name of the presiding officer, his signature, the year of the elections, and the time of close of polls at the polling station and date. That is the year of the election. That's the date. This was a requirement in pursuance of Regulation 43 of CI 127 and Regulation 3923 of CI 127.
You have a right.
Hold on. So we disputed. And they were insisting that it should be admitted. This was what generated the entire controversy. Today, so if the court says, in view of all this, by a Mandamus application, go and collect it, do you think me, the farmer, I will agree that those two pieces be collected when they are in dispute? It is not a Mandamus that will correct it. It is a full-blown trial, so that the person who deposed to affidavit that the pieces were in dispute, who will be put on the stand. Then I'll cross-examine him. That you have admitted that the pieces were completed, for instance, in your office after our agents, of the polling agents of all the contestants have left. So the law does not permit you to complete pinches in your office and come and give to candidate to accept.
So now, obviously you disagree.
Of course we disagree.
What's the way forward?
I think we'll advise ourselves, and I'm sure by the close of the day, you know the position of the party in this matter.
You have less than 2 days to go.
Yes, I'm saying. We are working today, Saturday. Right now, where we are, tomorrow is even material as a non-working day. We can be working tomorrow. So by close of today, the party's position in this matter, you will be advised and you will know. But this is not the end.
This is the central. Would you throw some more, share some views?
In fact, if we were in court, the court appears to be rehashing the same facts in respect of all the other respective constituencies. So, for instance, Techiman South, the judge mentioned 62 print sheets, when indeed that was not the issue in respect of Techiman South. Okaikwe Central, there were not 62 pink sheets. The judge was mentioning 62 pink sheets. So why? When you write a ruling, who corrected him? Gary Numaku corrected him from the bar. Do you stand at the bar and correct the content of a judgment being delivered by a judge? You bring an application on notice for correction of judgment in terms of facts.
Couldn't it be an
It could not. It could. Please. I will not go on that path with you. I am saying that where a lawyer stands at the bar and be correcting the content of a ruling delivered by the judge, we have a problem.
All right. So yes, the decision may have been rendered. The decision may have been rendered, but there are lots and lots of concerns that remain in this matter. Grace, you can hear that. Well, all applications have been granted. All 4 applications have been granted by the court. The Electoral Commission, by the grant of this application, is compelled to recollect the results in all of the 4 constituencies that came before the court. And these would be Ablekuma North, Tema Central, Okaikwe Central, and Techiman South. But if the indication we have just picked up from the Honorable Dafem Roxy Nelson Eche is anything to go by, then it means that between today, this evening, and tomorrow, we certainly will be hearing something from the NDC regards the decision that has been rendered by the High Court today. And so, as we speak now, the High Court may have been done with its job, but the parties certainly are not done. Grace.
High Court. Let's go back to him. He has more for us.
And we have heard them speak on this. I have Dr. Computer Tanko, who also wants to speak more on this matter. The Honorable Roxy Nelson Eche Dafemekwa has already told us that we should be expecting some response from the party, which most likely will depart from what we have seen today. Is that the same impression I'm getting from you?
Let me put it on record. They have brought a bucket full of lies and pour it in front of the judge. And he also succumbed to those lies, packed of lies, bucket full of lies. Told them a story that happened. And those stories were not cross-examined. It didn't lie in his purview. Because you know what justice means, natural justice means. Somebody has come to tell you pack of lies. This thing happened. And yet those people were not cross-examined by anybody. And he ruled in favor of those lies. You allow us, you think that we are going to allow this to stand?
Is it your position that in this case also, in today's, in the process leading to the judgment today also, your party was not duly heard?
we were heard on an issue of Mandamus. We were not heard on the substantive issue of what transpired at the collation center. It has nothing to do with that. The writ and the affidavit attached to it, if they were asking us to now come and defend on the issues, we would have asked them to come and we'll cross-examine them.
Is that not changing the case into a full election petition?
That is what he has done. He has ruled based on the full blown of the matter. So why should we expect as a party, NDC, to allow this kind of charade to continue? We are not going to accept it. We have filed a process. Nobody is going to do any collation whatsoever at that place. We are telling them we will not accept it. We are going to resist it. With all the legal powers that we have, we are going to resist it. We have done the processes, and we are telling them the easy. They should stop being lawless. If they do anything lawless against this, we will come after them.
Well, two important voices in the NDC that you have heard. You have heard Dr. Rashid Tanko, computer. He has also just reiterated practically, basically, what the Honorable Dafia Makwa has said, that the party is not taking what has happened. Well, the court has spoken, but they disagree, and they will not take it lying down, as the expression goes. They will, of course, file some processes on this matter and ensure that it is changed. Well, the indication I'm getting from both voices is that this was an election petition that was heard and not an application to compel a public officer to do his or her duty. That is the argument that the NDC side is making. We want to pick some voices from the NPP side as well, so that we see what the position from the NPP side would be. But I can see the candidate for Okaiko Central on the ticket of the NDC, Mr. Baba Sadiq, who is coming out, and we'll just try to have some word first with a lawyer for director of legal for the NDC. I am picking a lot of dissatisfaction from your side on the decision of the court today. Some of your people are saying this has become an election petition that has been heard and not a Mandamus application. Director of Legal Affairs, what is the direction of the party going forward? Order has been made, and I know that it becomes an order until you take an action. So what is the action that we are expecting from the NDC going forward?
Council, you've heard the decision of the court. What is your initial reaction?
Oh, like I said in court, you can only oblige what the judge has said. But I must say that it is something that we anticipated. So we came to court prepared with our notices of appeal. And as you can see, immediately the judgment was read, we ran to the registry of the courts to file the respective notices of appeal in respect of the 4 affected constituencies, as you can see. So with us here is the notice of appeal and the subsequent stay application. It is something that we knew was going to happen. With the ruling on the prelim, it was clear where the judge was going. And so we took preemptive steps to do what is needful. So I can tell you, and as you can confirm here, we have the respective notices of appeal. We have them here, and we'll take steps right now to get them, the legal requirement. The order must be served on the Electoral Commission before they can proceed. And like my lord said, they are now working on the order. We have our stay application, we have the notice of appeal, and we take steps. This matter is not ending here, and let nobody be deceived. This matter cannot end here, because you see, the matters raised, and if you are in court, it was as though my lord was hearing an election petition. This is a Mandamus application, for Christ's sake, and that is all that I will say. So we'll take all the steps to take.
But time is also running out. Time is running out. How are you dealing with the issue of time?
No, first of all, the court itself said because of the election and the nature, expeditious trial will be permitted. And we have taken steps timeously. Look at the time the judgment or the rulings were delivered. and look at the time we file our respective notices of appeal. That is the speed with which we want to do it, and we have taken all the necessary precautions.
Thank you, Honorable. But let me speak to some of the candidates also. Let me just find out. You were initially declared winner. Two of you were initially declared winners, and all of a sudden things spiraled out. You've been contested. They are questioning the win. How are you feeling?
Well, there was always a very curious, collusion between the Electoral Commission and, the NPP. Very obviously in my constituency, I will speak for my constituency. So right from the beginning, we could tell that they weren't going to allow the rules to apply, that they were going to always hijack the process and make sure that we didn't have a chance to deal with evidence as it's supposed to be, which is where we see that the veiled Mandamus